And ladies and gentlemen, our third presenter is Miss Wijesooriya. She's going to talk another important area, that's plant variety protection. Yesterday, today and tomorrow. She's a lecturer in Kotalawala Defence University and holds LLB and LLB from Colombo University, and she's reading for her PhD at Colombo University. Now, Mr. Wijesooriya, time is yours. Thank you.
Distinguished Chair, other speakers, ladies and gentlemen, good morning to you all. My topic is plant variety protection yesterday, today and tomorrow, with special reference to UPOV 1991 and TRIPS agreement. This is my organization of the presentation. Basically, I focused on the UPOV Convention, that is International Convention for the Protection of New Varieties of Plants, 1991, and TRIPS Agreement, that is Trade-Related Aspects of Intellectual Property Rights, 1994, and some domestic attempts. I slightly focused on the domestic attempts. My research problem is, does Sri Lanka have an adequate legal framework to protect plant varieties within the country? And these are my objectives of the research, that is to examine the function of the UPOV Convention and TRIPS in order to protect plant varieties. And my research methodology is based on literature survey in the area of law relating to plant variety protection at both domestic and international level. So basically, when we discuss what is a plant variety, we can give you a definition based on UPOV Convention 1991. According to this convention, plant variety is a plant group within a single botanical taxon of the lowest rank, which grouping, irrespective of whether the conditions for the grant of breeder's right are fully met. Further, this convention mentioned that this plant variety can be defined by the expression of the characteristics resulting from a given genotype or combination of genotype, and it can be distinguished from any other plant grouping by the expression of at least one of the said characteristics. And also, it can be considered as a unit with regard to its suitability for being propagated unchanged. Then, discussing or focusing who is a breeder, according to UPOV Convention 1991, in its definition says a breeder means the person who bred or discovered and developed a variety, or the person who is the employer of the aforementioned person, or who has commissioned the letter's work where the laws of the relevant contracting parties so provide, or the successor in title of the first or second aforementioned person. So, this kind of breeder can obtain or enjoy the right of plant variety or protection of plant variety when he proving this mentioned criteria, that is novelty, distinction, uniformity and stability. According to UPOV Convention, Article 6 of UPOV Convention, novelty is something new, that is the variety has not been sold or disposed of by or within the consent of the breeder. And the distinctness is the variety should clearly distinguish from any other existing variety. Article 7 says the variety is clearly distinguishable from any other variety whose existence is a matter of common knowledge at the time of filling of the application. a variety that is of common knowledge does not have to be protected variety. And there are two more criteria to meet. That is, one is uniformity and the other one is stability. Uniformity is the variety should sufficiently adhere in its relevant characteristics, that is described under Article 8 of UPOV, and the stability is these characteristics of the particular variety should be remain unchanged, and it is also discussed Article 9 of UPOV. And when we discuss the applicability of TRIPS agreement, according to Article 27, subsection 3b, it says that members, the state parties to the TRIPS agreement, shall provide for the protection of plant variety either by patent or by an effective sui generis system or by any combination thereof. So, this effective enforcement, we can define this effective enforcement as a mechanism and procedures for the multilateral prevention and settlement or equitable remuneration. So, when we apply this effective system to the UPOV, here World Trade Organization and UPOV Convention secretaries have given clear indication that they would consider the framework provided by the UPOV as an effective sui generis system, and also GATT, that is General Agreement on Trade and Tariff and Trade, said that TRIPS agreement provide for the protection of plant varieties but would leave them free to decide whether to grant such protection through patent or through effective sui generis system or by combination of these two. So, when we considering the domestic legal framework, there are two attempts, that is, actually these are the working documents. One is in 2001 based on breeders' rights, and the other one is in 2011 that is based on farmers' rights, breeders' rights and researchers' rights. In 2011, in its long title says that this act to provide for the establishment of an effective system for protection of new plant varieties and of the rights of the farmers, plant breeders and researchers to encourage the development of new varieties of plants and to provide for matters connected therewith or incidental thereto. So, comparing these two working documents, in first documents they have identified the breeders' right, and the next document they have identified breeders' rights as well as the farmers' right and researchers' rights. So, my suggestions are, as I explained, these two documents introduced in 2001 and 2011. So, you can see that it's an unnecessary delay is taking place to implement these laws in domestic level. So, we have to implement these laws to protect our plant variety or breeders' right indoors. And it's, I can, that is a positive, what the issue is also there, that is in 2011 Act, they have introduced farmers' rights as well as researchers' rights into the that working document. Thank you.
Thank you very much, Mrs. Wijesooriya, for enlightening presentations. That's another important area of the law, particularly agriculture and other areas.